very warm welcome to Drishti IAS. Good afternoon. My name is Ravi Pathak and today we are going to take up another important issue, or one of the important issue, I would use the word, as far as our scheme of polity, constitution and governance is concerned. So in today's class, basically we are going to discuss something related with one of the three wings of the government, that is legislature, executive and judiciary, and out of that we'll focus upon the judiciary aspect. So before getting into the details related with the judiciary, including the higher and the lower judiciary, the core of the topic today we are going to discuss is nothing but something related with the controversy, which is associated with appointment of the judges, or we can say you might have heard about Collegium system, or the NJAC, that is National Judicial Appointment Commission, and so on. So the whole idea for today's class is nothing but to understand this procedure of appointment of the judges, what are the issues involved in that, and reference made to those procedures may be in the form of different cases associated with this particular development, like first judge case, second judge case, third judge case, and so on. So ultimately we'll try to understand these things in a detailed and a systematic manner, so that if we get any question out of this particular topic, we must be in a position to handle that question with ease for both the segments of the examination. That is, if there are certain factual questions which are supposed to be asked in prelims, we must get the answer for that. And suppose they ask the same thing in mains from the analytical perspective, then also we must be in a position to answer that with ease and comfort. So now let's begin our session, and the core of the topic, as I've told you, is nothing but the controversy associated with collegium system, and the base of the topic is nothing but the appointment of judges. So let's move forward and see how we are going to proceed. So before proceeding, what I'll do, I'll try to give you the overview. When we say overview of the topic what we are going to study, let's say for example the topic is XYZ. So for this XYZ, what our approach would be as a student, if I have to understand this topic, let this topic be anything, then the first and foremost approach would be, I'll be understanding this topic from three perspectives. One, the perspective of PT, preliminary test, that is the factual data or the factual information which is associated with this particular topic, we must be clear with that. So all the information which are going to be part and parcel of the facts that will be included in the PT mode discussion, and then the same topic we are going to take up when we'll talk about the mains perspective. So here our approach would be more or less, it would be analytical rather than the factual, and here it would be based upon the facts, or in simple terms I would say based upon the concept, that is understanding the concept and applying that in analytical manner depending upon the question or the demand of the question which had been popped up in mains part. So while analyzing the issue, we'll take up the various aspects that if the question comes for discuss, examine or comment, how to proceed with that. And at last we'll take it from the maybe interview perspective, that if some questions are asked in interview, that is adding the current affairs, any recent development as far as this topic is concerned, which will be helpful not only for the personality test, but definitely it will help us in the prelims part also and mains part also. So that is the common approach what we generally follow in our regular classroom program, and here also we are going to take that approach for whatever the topic we are going to deal with this particular class. So today, as I've told you, we are going to look into the topic which is nothing but the core aspects, or we can say the base for the state or the government, where it has been divided into legislature, executive and judiciary, what we also know as system of checks and balances or theory of separation of power. However, for today's session, we are not going to discuss the things which are there in legislature part or the executive part. Our focus today is nothing but we are going to put more emphasis on judiciary part. So here we have to understand the judicial aspects or the aspects which are related with the judiciary. So let's see what we are going to discuss today as far as the judiciary is concerned. As I've told you, so there we are going to take up in judiciary, which we actually follow in other topics also, legislature and executive and so on. So in judiciary, what we are going to do is nothing but we are going to talk about a couple of things, and whenever we get these things, then three things are very important which we need to know before proceeding with the topic. One, when we talk about judiciary, then exactly the three things what we have to study in any topic, if it is legislature or executive also, then the first thing we need to understand is nothing but appointment, right? So here we can say appointment not of judiciary but of the judges. Judiciary is an institution or a sort of organization. The functionaries who are associated with that institution, so-called judges, their appointment. After completing the appointment, we have to look into the another aspect, that is removal. So once they are appointed, they may be removed also. So what are the process which is associated with their removal? And third part, which is very important, is nothing but we have to look into the associated powers and the functions which are accorded to them, maybe by the supreme law of land, that is, let's say, Constitution. So what kind of powers and functions had been given? Now here you have to understand one thing very clearly. When we talk about the appointment and removal, this segment deals with, as I've told you, the functionaries which are there, or so-called judges, right? But here when we talk about the functions and power, then this would be for the institutions or the organization. That is, we are going to deal with the powers and functions of Supreme Court, High Court and the lower court or subordinate court, not the judges. But when we talk about the appointment and removal, there our focus would be more on the judges, the functionaries, the Chief Justice or the other judges of the Supreme Court or Chief Justice of High Court and the other judges of High Court. And today's agenda or today's topic is primarily associated with the first part, that is appointment of judges. So when we talk about appointment of judges and looking into the details, or before getting into the details, let's try to understand the basics and the constitutional provisions associated with their appointment, and then we'll move chronologically, that how the issue of collegium system came into and how the NJAC came into existence, how it was abolished or declared unconstitutional, and what is the present position. This is the idea which we are going to learn in today's class. So this is sort of a backgrounder that from where we are picking up the topic. We are taking up the topic judiciary, which is nothing but, I've told you, is a integrated part of legislature, executive and judiciary. Out of that, this already we have discussed in the class, and now we are focusing upon the judiciary. So shall we go ahead? Perfect. Moving further, when we talk about this particular thing, then the first part what we need to understand is nothing but the constitutional provision. Now when we talk about the constitutional provision, then as far as the appointment part is concerned, that is the first part, appointment of judges is concerned for the higher judiciary. So here we are going to see the constitutional position as far as the appointment of the judges are concerned in the higher judiciary. When we say higher judiciary, that means will include Supreme Court and High Court, both. And below this, the lower courts, they are called subordinate judiciary or subordinate courts. So that part will not discuss today. Rather, we'll focus only upon the Supreme Court, more likely, and to some extent for the High Court as well. So here when we talk about the constitutional provision, as far as the appointment part is concerned, then the whole judiciary segment is somewhat, as I've told you, if you see the classification, legislature, executive and judiciary, then you'll see that it has been given in a very integrated manner. Like for legislature, we have legislature at the union level and the state level. As of now, we are focusing more upon the union part. So here we can say the articles which are there for the legislature, executive and judiciary, it is not given in the same cycle, rather executive is first given, then we have the legislature, and in third place we have the executive. So here we can say in constitution, U by A implies under article 52 to 78, we can find the mention about the executive part, that is the president, vice president, prime minister, council of minister and so on. Then when we talk about the legislature, this is dealt in our constitution again in part 5 only, from article 79 to article 122. That is about the legislature, or what we commonly called as parliament, Lok Sabha, Rajya Sabha, speaker and the other functionaries and their powers and function. And when we talk about judiciary, then it is mentioned in article 124 to article 147 in the constitution. So our approach today, or our focus today, would be on this particular article. But as I have told you, this is in part 5 for the union judiciary. That is, we can say the judiciary at the union level or a Supreme Court. When we talk about the counterpart, then here again article ranging from 214, just play with the number 124, 214 to article 231, we can say basically deals with the state part, or we can say the high courts. So mainly you have to remember in discussion article 124 for the Supreme Court part, and here for the High Court part. And in that also, when we talk about the appointment of judges at the High Court level, then the most important article we have to look into is article 217, which talks about the appointment of judges of High Court. So just two articles here to remember, one article 124 for this discussion and other article 217, because 124 talks about appointment of judges at the Supreme Court level and 217 talks about appointment of judges at the High Court level. So I hope now you are clear with the constitutional provision also, or constitutional arrangement as far as this three important wings of the state or the government is concerned. Now moving further and looking into the first part, that is nothing but the article 124, which is related with the appointment of judges at the Supreme Court, and later, as I've told you, I'll talk about article 217 also, which is related with the High Court. So here we'll deal with the Supreme Court, and here we'll take off with the High Court, and the essence is appointment of judges. Now when we talk about the appointment of judges, then as per the constitutional mandate, or we can say the letter of the constitution, right, the process is very simple, and this process is simple till certain extent, but there was certain changes introduced over a period of time as far as the appointment process of the judges is concerned, and that is what we have to understand. So two ways of understanding this topic is there, and we can understand by either of the way. One, we can move ahead as the things proceeded. Other, we can have a background understanding of the appointment of judges or the power balance between the legislature, judiciary and executive, and accordingly understanding that what happened chronologically right from independence till today. So whichever way you are comfortable, we can go ahead with that, and here I'll give you the insights related with both the approaches, so that it would be easy for all of you to understand either of the approaches. Now when we talk about the appointment of judges, why this controversy and issues related with, let's say, the collegium system, or why the onset of NJAC is important to us, right, and what are the case studies or the cases which are associated with that. This is our agenda. This is what we are going to understand. But before understanding that, we need to understand the reason also, that why this kind of things came up. And for that, I'll take you maybe for next 5 to 7 minutes to understand the background, and then we'll get on to this particular analytical debate or analytical discussion. So as I've told you, to understand this, the first thing we have to understand that this separation of power, what we can say, and the mechanism of checks and balances in the form of legislature, judiciary and executive. This part we have to understand, though I had discussed this in detail when we were doing the fundamental rights. But now, once again, ideally or hypothetically, we have to see, then legislature is equated to judiciary is equated to executive. That is, their relationship is nothing but a coordinate relationship. That is, all of them are equal. However, if any one of them tries to supersede the power of one, then the other two, let's say legislature is trying to encroach upon the judiciary or the executive, then these two will try to control them. And that's why it is also known as game of checks and balances, which I had clearly explained you. However, in practical scenario, what happened, this equation is more of a subordination. Like whenever there would be a chance, legislature will try to dominate and the judiciary and the executive will become the subordinate. Or the judiciary, if the executive gets the chance, they will try to subordinate the legislature or the judiciary. And the third possibility is judiciary trying to dominate and making the legislature or executive as the subordinate. So this cycle actually goes on. And this is some sort of vicious cycle which we are still continuing with that. However, it depends upon the power, the function, the personality of the incumbent in the various institutions, the kind of prime minister we have, the kind of political party we have, whether it's a majority or a coalition, and the kind of the judges or the judicial institutions. But one or the other at a given point of time, they will try to subordinate. That means theoretically it's a coordinate relationship, but practically it's a some sort of superior and subordinate relationship between these three organizations. So whenever they get the chance, they get to, have an edge over the other two. So to best understand this, just in quickly, couple of minutes I'll tell you, we have to understand this issue, right? Obviously after the independence, so we can say right from 1947 till 2021, if we talk about this evolution part, that how the relationship between legislature, judiciary and executive has evolved over a period of time, then it would be all the more easy for you to understand the appointment system or the collegium system or the other controversies associated. So primarily I can divide this into a couple of eras. Like for example, when we say the era wise, then I will classify them in, let's say, Nehru era or Nehruvian era. Then we have another era, that is Gandhian era. Please don't get confused with Mahatma Gandhi. Here we are talking about Mrs. Gandhi, that is Indira Gandhi, including, let's say, Rajiv Gandhi also. And then now we are witnessing something called coalition era. But in coalition era also, from 90s to 2014, when we got a party which is in majority, though NDA is in majority, but it's a NDA, National Democratic Alliance. That's a group of regional parties. Still BJP enjoys the majority. And on timeline basis, if I have to see, then I can say somewhat, let's say 47 to 64. Then here I can say, let's say 66 to maybe 84, or if extended to Rajiv Gandhi also, then around 90s, and post 90s till today we can say that the coalition. Now I am trying to explain this era so that you can understand the background part. So here when we talk about the Nehruvian era, this is also called era of idealism. Nehru was little bit idealistic, which you might have studied in your international relations classes and so on. So he is the one, in spite of being a powerful executive, but he gave the primacy to legislature. Most of the decisions were passed by taking the parliament into consideration. It was not like that the suo motu initiative or being a powerful executive charismatic personality. If he would have wanted, he could have taken the decision, but he promoted legislature more, and there we can see the clear-cut subordination of executive as well as the judiciary in the first spell. In between, we have a short span of Mr. Shastri, but that time was so less that calling it an era would not be justifiable. So here we had seen that legislature gained the supremacy, but in Gandhian era or Mrs. Gandhian era, here we had seen that executive was dominating and they have subordinated both. The decisions taken by Mrs. Gandhi, many examples can be quoted, wherein she had bypassed the legislature as well as the judiciary to a certain extent, and there was a huge or large degree of conflict between the executive and the judiciary. Most of the important cases, if you have gone through, right, let it be the cases related with the Keshwanand Bharti case and the bank nationalization issue, or carrying out the Indo-USSR Friendship Treaty against the non-alignment movement, or conducting the nuclear test, imposing the emergency in the country. Many realistic decisions she has taken. So this is also known as era of realism. And there she was enjoying more power by subordinating the legislature and the judiciary. So judiciary, you can see for the first 40 odd years, they were subordinate only. But one beautiful phenomenon of Indian polity is what? Whenever there would be a coalition government, that is, government is weak, or the executive is weak because of the fulfillment of the obligation of coalition dharma, there the judiciary gets the space. And here we can see this particular era as domination of judiciary, and they have subordinated the legislature and the executive. So many things, whether we talk about the right from judicial review to introduction of public interest litigation, or the concept of basic structure, and today judicial activism, or some people term it judicial overreach or extremism, also can be witnessed in that particular era. But as I've told you, till 2014 we have witnessed the high degree of coalition, but in 2014 we had got a majority party government, though it is a coalition government only, but majority party. So there we have started seeing some swing in the sense, here we are seeing that executive is again trying to come up and trying to subordinate the legislature or the judiciary. Many cases, later on I'll give the example also, that the judges coming out openly in media and saying save us and then we'll save you, or scrapping, making up of a National Judicial Appointment Commission, and then Supreme Court again scrapping that. All this agenda will be clear when we'll enter into that particular debate or that particular era. So this is what the background. I would request you to keep it at the back of mind. This is not important. This is just a general framework or a backgrounder, so that you can understand from where we are picking the issue and from where actually the issues related with NJAC or the collegium system started. So if I ask you where it started, then very clearly we can see that somewhat in the middle, or we can say in the phase, so-called Mrs. Gandhian phase, the issues started popping up. So in Nehruvian era, there was a different system altogether as far as the appointment is concerned, and it was very smooth because it was as per the constitution, right? But in Gandhian era, things have changed on multiple places, and one among them was related with the appointment of judges. And when we come to coalition era, then we'll see the issues related with the NJAC and all those things. So if somebody asks you where exactly we begin with the collegium system and the controversy related with the appointment, basically we have started during the Gandhian era. This was the idea which I wanted to explain you, that from where we have got the origin of this particular debate. I hope it's clear now. Perfect. So let's move forward and see what exactly happened in all those three eras and today where we are. So when we talk about the first thing, as I've told you, as per the constitution or under the constitutional provision, let's say we talk about Article 124, and Article 124 clause 1 and clause 2 both talks about the appointment part only. And in a nutshell, if I have to understand that, okay, if we have an institution, let's say judiciary, so here who will appoint the judges? So it's related with the appointment of judges, no doubt about it. And as far as the appointment of judges are concerned, as per the constitutional provision, the judges would be appointed by none other than the President of India. So when we say President of India, President is nothing but part of executive. That means executive is the one who used to appoint the judges. Things were smooth, no doubt about it. And Mr. Nehru had continued this convention, during his whole tenure, right? The appointment of judges were continued to be by the executive only, and by the principle or the letter of the constitution, what we can say, or as per the provisions which are mentioned in the constitution. So the point is, what was the provision which was mentioned in the constitution? So when we say what was the provision, here it says that the judges of the Supreme Court will be appointed by none other than the President of India, right? And as far as the appointment of these judges of Supreme Court is concerned, for that President of India may consult or will consult some judges from both Supreme Court also and High Court also. That means there was a mechanism for consultation with couple of judges from Supreme Court and High Court for appointing the judges of Supreme Court. That was the established mechanism. However, for Chief Justice, the idea was nothing but the CJI will be appointed based upon a principle that is nothing but related with seniority. So, the senior most judge in the Supreme Court will be appointed as Chief Justice, and the other judges will be appointed by the President only. However, for that the President will consult certain number of judges from Supreme Court and High Court. Though, point here we need to remember is how many, that is number of judges to be consulted was not fixed or not given in the Constitution. Constitution is basically silent on as far as the number of judges to be consulted is concerned. But Nehru followed this convention, and the judges, especially the Chief Justice, they were appointed based upon the principle of seniority, and the other judges were appointed after consulting the number of judges as the President may think fit. This is what the word used in the Constitution. So, whatever the number the President thinks fit, and when we say President thinks fit, that means what? The decision of the executive only, because earlier you might have went through the articles like 74, 75 and so on, that President of India acts upon the aid and the advice given by the Council of Ministers, which is headed by none other than the Prime Minister. But the whole point is executives are the one who used to appoint the judges in the judiciary. This is what the idea. And later on, this power of appointment of judges from the executive was taken by the judiciary. That is why the controversy has started. But as of now, the things were smooth. Only one incident was there during the Nehruvian era, that one judge who was appointed by superseding the seniority, and that too the reason was very much logical and acceptable. Why logical and acceptable? Because the senior most judge was unable to discharge his duties because of the serious health issues. And that's why Mr. Nehru had requested him to resign first, and then the next senior most judge was appointed as a Chief Justice. So the point is, in Nehruvian era, the constitutional morality and we can say the legality had been maintained and the appointment process was very much smooth. I hope it's clear. Perfect. However, as I told you, the controversy started when we came into the second phase, that is nothing but the Gandhian era, because we are not considering the tenure of Mr. Shastri as an era because of the short tenure. But in Gandhian era, what happened, especially in the late 60s when we talk about, then the situation started deteriorating. And during Gandhian era, there were a lot of conflicts which are associated between two wings of the government. One, the executive part, and the other, the judiciary part. So here, what were those controversies which you might have read them in the regular classes as well, but n number of things were there when we talk about this. Because while studying the fundamental rights and the cases related with the amendability of the Constitution, we had seen the drift which was there between Mrs. Gandhi and the judiciary, or we can say the executive and judiciary, Article 13 versus Article 368. That controversy we are well aware with as far as the amending power and the role of fundamental rights are concerned. So there we have gone through a couple of cases which you might be remembering, including the important cases like Golaknath case, or for that matter the very famous Keshwanand Bharti case. So let's say 1967 and then 1973. These things we had already dealt with. Now, the KBC and the other aspect in Article 13 and 368, that is amendability of the Constitution, is a separate topic altogether. So here we'll not be dealing with the nitties and gritties of those topics, but we'll be focusing upon only that component or that part which is relevant for our this particular discussion. However, along with that, the controversy, or maybe we can say the other dispute which are related with fundamental rights versus DPSP, Directive Principles of State Policy, in which the nationalization of the bank case and all those things had been covered and taught to you. So I would request you to keep that or bring that background also. here so that we can understand them easily. Now, we all know that what happened in KBC case, and little bit of it I have to discuss here so that I can make you understand that how the rift between the executive and the judiciary had started. And by this time, I would say the judiciary was trying to acquire more weapons. They have started with the judicial review from Article 13. Then in KBC, they came up with Keshwanand Bharti case, they came up with the doctrine of basic structure. Then we also know about public interest litigation and leading to judicial activism. Those line or those developments, you have to keep it in mind to understand this issue in a simpler manner. Now, when we talk about here in Gandhian era, then what happened here, that as far as the Keshwanand Bharti case was concerned, the historic verdict which was delivered on 24th of April 1973, there we had seen that the constitution has got the power to amend, the legislature has got the power to amend the constitution under Article 368, which also included part 3, that is fundamental rights. However, another doctrine was propounded that it must be subjected to the doctrine of basic structure. So this basic structure doctrine was propounded, and here try to understand the phase, how it was gradually moving. Basic structure was not defined by the Supreme Court. Time and again they have given more than around 25 different things had been incorporated into the ambit of basic structure, but still basic structure is not clearly defined. It has to be understood in its literal sense rather than a meaning or a definition format. So on the name of basic structure, the things were sorted out in KBC case. Later on we have a Minerva Mill case also, that is another important case. We will discuss some bit of it later on. But after this basic structure or the delivery of the historical judgment on 24th April 1973, the next day itself, right, 25th April, the appointment of judges controversy started. Why started? Because somehow it is also related with the KBC case only, where the government tried to manipulate the judges as far as the judiciary is concerned to get the decision in favor of the government. So what actually the idea was in this historical case, so-called KBC, this is a watermark, or we can say a paradigm shift in the Indian legal history, and in 1973 the judgment was decided to be, or to be decided by 13 judge bench. So 13 judge bench was somewhat, we can say, one of the highest constitutional bench which was appointed till that time to decide upon a case, and the verdict pronounced was 7-6, that is 7 pro constitution, we can say, to uphold the sanctity of the constitution, and 6 we can say the pro government. So before that the government wanted the decision to be in her favor, but it doesn't happen. The 7, that is the majority part, were through the pro constitution. That's why we had upheld the doctrine of basic structure, that is 7 judges supported the concept and the 6 judges were against this particular doctrine. So this was the idea basically, but here the manipulation started in these numbers, or what we can say in this judges. So after 73 or after KBC case, what happened? The next day itself, the Mrs. Gandhi decided to appoint the judge who is not a senior most judge, rather than he was 4th in rank as far as the seniority is concerned. So Justice Shallard, Justice Hegde, you might be knowing about this name, but the most important was, I can say, Justice Khanna. So Justice A.N. Ray and Justice Khanna. So she elevated Justice A.N. Ray, who was 4th in seniority. Before that, 3 more senior judges were there to be appointed as a Chief Justice. That means, what was the idea here? Idea here is nothing but, as far as the appointment of judges are concerned, then it has to be done by the President only, no doubt about it. But as far as the appointment is concerned, the seniority which was established by Mr. Nehru, that senior most judge would be appointed as a Chief Justice, that convention was broken. So now I have told you that it was broken once in Nehruvian era also, but that was on a logical ground. Here there was no logical ground of bypassing the senior most judges 1, 2, 3 and appointing someone who is at the 4th position, that is Ajit Nath Ray, Justice A.N. Ray. He had been appointed as a Chief Justice who was 4th in seniority by bypassing the Hegde, Schell and all those people. So, out of animosity, obviously, by maintaining the dignity of judiciary, these 3 people resigned. So, they have submitted their resignation and Justice A.N. Ray was appointed as a Chief Justice. That is the first major change, what we can say, or in simple term, if I use the word politicization of the judiciary, had been witnessed during Mrs. Gandhian era. And from here, the controversy has deepened or found the root as far as appointment of judges is concerned. And this was in 1973 and again in 1977. The same thing had been repeated. Basically, in 1977, before that there was a very famous case known as Adm Jabalpur Case or habeas corpus case, which you might have heard about. So, in that particular case, Adm Jabalpur or the habeas corpus basically, habeas corpus is nothing but a writ which is issued by the Supreme Court under Article 32. So, under Article 32 and under Article 226 for the High Court. So, this is for Supreme Court and this is for the High Court, what we call as constitutional remedy, and to protect the fundamental rights. If fundamental rights of the person had been violated or citizen had been violated, they can go to the Supreme Court, and this part also you might have studied in your fundamental right. So, here it was with the onset of emergency and post-emergency, you know, a lot of human rights violation takes place, and habeas corpus simply implies to have body. So, to have a body means the persons whose rights had been violated, and the person who had violated, the court may ask the custody or that body to be presented. So, that part you already knowing as far as the habeas corpus is concerned, and the idea was whether the habeas corpus can be issued during the emergency or not. This was the case, and again it was a 5-judge bench, because for constitutional hearing or matters related with the constitution, we need the minimum number of judges to be 5. So, this was a 5-judge bench, and out of that 4 judges were in support of the government and only 1 judge, that is nothing but Justice Khanna, who was against the verdict. That is, the 4 judges said that there is no need to, or habeas corpus cannot be issued during the emergency, but he was the one who said that no, it must be issued so that the fundamental rights guaranteed to the people must not be violated. It might be against the Article 21 as well. So, Justice Khanna did not supported the argument, and here when we talk about the next year, that is appointment of the judges case, then again Mr. Khanna, who was supposed to be the next Chief Justice to be appointed, he did not been appointed by the government as the Chief Justice. Rather than that, the other person had been appointed as a Chief Justice. That was the second superseding case. What I am trying to tell you is nothing but the seniority principle, which was actually established not only by the constitution but even during the Nehruvian era, was grossly violated, and most importantly for these 2 times, one in 77 and one in 73, as far as the appointment of judges is concerned. There this principle had been violated. Are you clear about the background a little bit more? And then 80s onwards, the Supreme Court has started taking a call, because you know that after 80s, when Mrs. Gandhi came back in power, then the government was slightly weaker than what it was before, and later on we had started with the coalition politics as well. So there, what happened? Whenever the coalition would be there, judiciary will try to gain the primacy or supremacy, I can say, and there onwards we can see the onset of public interest litigation, judicial activism and so on. So this was somewhat beginning. Now judiciary wanted to fix this particular issue, that as far as the appointment of judges are concerned, how that can be regularized or how that can be taken into the hands of judiciary only. So this is just here to keep in background, though it's a very important case, but here it is not required to be discussed in detail. So moving further, now as far as the appointment of judges are concerned, there we have to go through some of the important cases, and here to understand the process completely, these cases, these are popularly known as the judge case or first judge case, then second judge case, and so far now we have 4 judge case. So third judge case and the fourth judge case. Now what these cases are and how they are related with the appointment of judges into the higher judiciary. So the background here is, again you have to keep one thing in mind, that is what? When we talk about the appointment, so far now what was happening? So far now what was happening, that let's say this is the institution of judiciary, and the institution of judiciary, the judges were appointed what? By executive, that is by the president, no doubt about it. However, president needs to consult some people, maybe the judges from the Supreme Court and the High Court, but the number was not fixed. And here if we see, the role of judges or the judiciary was very limited, because this consultation which was supposed to be taking place between the president, that is the executive, and the judicial members was what? Not a sort of binding consultation. This is the first thing. So here the controversy started with the word consultation only, and very shortly I'll explain you the meaning and all those things associated with this. But prima facie, if you see how the president appoints the list, let's say council of minister, whenever there is a vacancy in the Supreme Court headed by the prime minister, they used to forward that particular list to the president, right? Let's say for example there are 3 vacancies, so they may recommend the name of 5 people, and out of this 5, let's say these 3 are going to be appointed. So this name of 5 people will go or will be prepared by the council of minister, which is headed by the prime minister, and then prime minister will take that to the president. What president will do? President will have a consultation with couple of judges from the Supreme Court and the High Court both to appoint those judges. This is what the ultimate process was. That means the power of appointment was really in the hands of executive, and as per the article 124 also of the constitution. But slowly what happened, the Supreme Court or the judiciary has tried to encroach upon this particular power. That is, they wanted to take this power of appointment from the hands of the executive, right, or the council of minister or prime minister, back into the hands of judges only. And that's why this tug of war was going on. So let's see how this controversy had started and how it has been settled. But up till now, what was the case, or what was the base? Base was the judges are going to be appointed by the president, and the recommendations or the list or the names would be given to the president by the council of minister or the prime minister, not by the judges of the Supreme Court. That is, judiciary doesn't have any major role to play except the consultation. Now, judiciary people are very smart, and they found this word interesting and they started interpreting. So how they have started the interpretation part and how they have manipulated this, that can be clearly understood when we talk about these cases. And after understanding these cases, it would be very much clear to all of you that what exactly the controversy related with the collegium system is, because till now there was no concept of collegium system. But it has started, let's say, from the first judge case. We got the seats in the second judge case. It was crystallized in third judge case, and fourth judge case is related with something else, that is NJAC. And today we are having that collegium system which was actually taken the shape in third judge case. So how they are, let's try to understand in next 10 to 12 minutes. And after that, we'll come back to again that discussion of the coalition era or the relationship between the judiciary, executive and legislature. I hope it's clear now up to here. Perfect. So when we talk about this particular thing, let's try to see the cases. Now when we talk about the first judge case, terminology wise we use the first judge case because related with the appointment of judges. However, theoretically this case is also known as SP Gupta case. So it is known as SP Gupta case or SP Gupta versus Union of India case in 1981. So till 77 we had seen that Mrs. Gandhi had toppled up the junior judges to be appointed as CJI, and then it was challenged by a petition in SP Gupta case, and there the judiciary has given the verdict which I can say was more or less in favor of executive only. Why? Because still you see the era, Gandhian era, still Mrs. Gandhi was there and the executive was powerful, judiciary was subordinate. So here The controversial word, as I've told you, was nothing but consultation. And as far as this word is concerned, consultation, here the petitioner was asking that whether this consultation is a concurrence or not. So the another word, the meaning of the consultation was concurrence. Now what do you mean by concurrence? Concurrence is nothing but some sort of binding, because consultation is what? If you are consulting, if you are discussing something, let's say you are a patient visiting to a doctor, you do the consultation. Whatever the prescriptions or descriptions he provides you, that may not be binding on you. But if it is a concurrence, then it is binding. So it is somewhat what? I can say or use the word advisory. And here it becomes binding. So the game started, and here the interpretation of the word started. But in first judge case, what the judgment which was delivered by the Honorable Supreme Court was said that the word consultation does not means concurrence. That means it is what? It is advisory. Which consultation? The consultation which President of India is going to do. With whom? With certain number of judges. Still the numbers were not fixed. Certain number of judges from the higher judiciary. So these judges with whom the president is going to consult what? They are going to consult about the list which is provided by whom? By the Council of Ministers, or we can say which is headed by the Prime Minister, so we can say directly the Prime Minister. So these names which are going to be what? Given to the president, on these names out of 3, suppose 1 is to be appointed, then he will also consult certain number of judges from Supreme Court and High Court or higher judiciary, and after that he will appoint the one out of the 2. But whatever the decision which is going to be given by these people, so-called certain number of judges, whether that is binding or not, and binding or not on whom? Binding or not on president. So this consultation is binding or not? This was asked. But the answer is no. It was not a concurrence. That is, it is not binding. However, court said one very important thing. Though it is not binding, but it must be what? It must be effective. So what is the meaning of effective? Effective means, first of all, the president must honor it, and second thing, whatever the names which President of India is bringing from the Council of Ministers, right, we must also get the information related with those names, their performance, their output, the cases which they actually entertained with or given the judgment, and all those things we also need to know, so that we can give a rational decision. And here it should not be binding, no concurrence, but it must be what? It must be effective. So this must be taken into consideration. This is about the first judge case, or I can say still the situation was same. What was the situation? The situation was that still the executive is appointing the judges and the recommendations are coming from the Council of Ministers. This was the situation. But this situation was only till 1993 when we came up with the second judge case. So in second judge case, what happened? Exactly the same thing happened. What happened in the Golaknath case before the Keshwanand Bharti case. So that part also you know, that in Golaknath case, the Supreme Court has reversed its earlier judgment which was taken in Shankari Prasad and the Sajjan Singh case almost 180 degree. And the same thing had happened in this part also, that when the second judge case came into consideration, that is, it was in 1993. Now second judge case, we call it terminology wise, otherwise it is also known as the Supreme Court Advocate on Record case, or Supreme Court's Advocate on Record Association case. So this is the name of this particular case. However, popularly it is known as second judge case. Now what happened in second judge case? In second judge case, the Supreme Court had reversed the earlier judgment. And what they said, that the word consultation, which is there, is what? Means concurrence. That means they had what? Made it binding. So this is the first. This is very important case, and here a couple of outputs are there which we need to understand. So first thing what they had made is nothing but whatever the consultation the president will do with that certain number of judges which was not defined till second judge case, that will be what? That will be binding on the president. Now here the things have started changing dramatically, because if they are making it binding, that means what? Virtually they are taking the power of appointment of judges from the hands of executive to the judiciary. And this is what the crux which we need to understand, and this is what the case in which the beginning of collegium system started. So first thing what they said, that this consultation is what? Binding. Second thing what they said, that it should not be, there should be some numbers which needs to be fixed. It should not be as the president deems fit or thinks fit. So they have fixed the number also. They have said that for this consultation we are going to have a collegium system. So that's how the collegium system began. And this collegium system will comprise of what? This will comprise of CJI, Chief Justice of India, plus two more or two senior most, after CJI, two senior most judges of the Supreme Court. That means it's going to be what? A 3-member body for appointment of the judges of the Supreme Court. That is, a collegium would be established. Collegium, a college, plural body will be established, wherein 3 members would be there. One is CJI and other is what? 2 senior most judges, which would be there. And the President of India needs to what? Consult. The consultation would be happening between whom? Between the President of India and the collegium system. This is the first important point which we need to know. The first is consultation had been made or equated with concurrence, that is binding. Second, the collegium system, that will be comprised not as the president may thinks fit, but the numbers are fixed now. It would be CJI plus 2. There are a couple of more things which we'll discuss about this particular aspect, but apart from that, here the third thing which I have told you, initially the power of appointment of judges were in the hands of executive. So from where the recommendations used to come? The recommendations used to come from the Council of Ministers, which was headed by Prime Minister. But now the recommendations, that is the names which will come to the President for consultation, would be what? From the collegium system. That means this collegium system will not only consult with the President, that is binding in nature, but the names also going to be given by the collegium system. That is who will be appointed as the next judge of Supreme Court, that also will be decided by the judiciary. That means it was what? A sort of virtual, we can say, takeover. A virtual takeover of what? Power of appointment from the executive hand into the hands of judiciary. And definitely we know, I mean, this was criticized also, and we know that what? It is against the healthy principle and spirit of democracy, because you'll be surprised to know India is one among those very few countries where this kind of arrangement works. Otherwise, most of the developed and the democratic countries in the world, there the power of appointment of judges lies with, or let it be anything, executive power is the power, or one of the power of the executive is power of appointment and removal for a healthy democracy. But here it has been violated. So definitely people will ask the question, and when the questions were put forth, then some justification also came that what was the reason behind taking this call. So Supreme Court gave a number of reasons also, that these are the reasons. Some of the reasons you can highlight to substantiate in your answer if the question demands so. Like for example, the argument given in the favor of the collegium system was that when the appointments which are done by the executive, that is the president side, or we can say the Council of Ministers side, headed by the Prime Minister, recommended to the President, and then the consultation is done between the President and the some judges. What were the problem here? So here the problems or the argument was that the first argument given was that a lot of political appointments are taking place. That means here, rather than the judicial appointment, a lot of political appointments taking place because they are obviously coming from this particular part. Not only the political appointment, that means what? Political appointments here means what? They do not have the requisite efficiency or the skills or the expertise which are required for what? To be performing as a judge of Supreme Court. Then the issue related with nepotism, favoritism. I hope you understand these terms. Nepotism, favoritism, and so on will start in judiciary also. Because here those people are appointed as the judges who are very close to that particular political party and all those things. So a lot of nepotism, favoritism may come into picture. Then judiciary, which is considered to be what? Enjoying the highest degree of trust compared to other two wings of the state in the minds of the people, is also deteriorating. Why? Because here the issue of corruption also had started popping up in the higher judiciary. Justice Dinakaran, Justice Soumitra Sen, and some others are the example. So like that, judiciary put the allegation. Plus they said that it is also leading to a lot of delays. We need the judge today, we are getting it maybe after 2 years. So pendency of the cases are increasing. Like that, they have given multiple arguments. For what? For the appointment of judges through the executive side. This is, you can remember for writing in your mains. So going back to again the second judge case, what points you have to remember? Second judge case, that nothing but consultation was what? Made as concurrence, which is binding. Collegium system, CGI plus 2, the numbers were fixed. Then this consultation which is going to be, or this recommendation which is going to be there for appointment of judges, will come from the judiciary side. That means indirectly we can say judges will appoint the judges. So giving this reason, you may be asked to give certain more arguments if the question is for examine or critically examine and so on. Then you can say, is it good for democracy? Certainly not. And especially in the long run. Because if the power of appointment or judges started appointing judges themselves, the logic is what? Why the power of appointment is given to the executive? Because executive is the one who is answerable to the people, but judges are not answerable to the people. Judges do not have any accountability directly towards the people. They are accountable to themselves. They are appointing themselves. So it is also violating the principle of natural justice. So a lot of issues were. However, as per Constitution, we know that judiciary is the final interpreter of the Constitution. So if they are changing the meaning or the word so-called consultation to the concurrence, that means what? That means we have to follow the same thing because they have interpreted. But the problem is that if we use the word consultation as a concurrence everywhere in personal life and the professional life, it would be very difficult to move forward. And even in the Constitution, wherever we have used the word consultation, if that would be replaced by the word concurrence, then don't you think it would be more difficult? Secondly, when we talk about, apart from the argument over the word consultation, then here, when Supreme Court said that consultation is binding, then President being the highest executive authority in the country, how come some decisions would be binding on that authority? So that argument was countered by Supreme Court again, saying that it's just the same way that Council of Ministers, when they aid and advise the President, it is binding on the President. But there the argument was given that by the executive, it is binding, but President can send it once for reconsideration. And the reconsidered opinion will be binding on the President. So for that, the judiciary has given the liberty, and in third judge case, very shortly we'll see, they have said that fine, let the President send the opinion once for reconsideration if he is or she is not satisfied. And if the reconsidered opinion goes back to the President by the collegium system, then it would be binding. So that part we'll discuss in third judge case. But I hope the first two cases are clear. Perfect. Then let's move on to the third judge case. Now what happened in third judge case? In third judge case, which was there in 1998. This third judge case basically is based upon what? The reference case, what we can say, or a presidential reference case or advisory jurisdiction of Supreme Court, which you might have read about in article or under article 143 of the Constitution. So in 143 of the Constitution, what it says? 143 of the Constitution says that the President of India have the liberty to consult or refer the matters on which the President seeks to get a legal opinion to the Chief Justice of India. So it's somewhat like 143 when we say it's some sort of, again, a consultation only between CJI and the President. Here also they can consult, they can discuss, but the difference is here the consultation is not binding. So not binding on either of them. Let's say President is asking something to Chief Justice of India or any matter on which the President want to have the legal opinion of the Judiciary, they can refer the matter to the CJI. But it is not mandatory for CJI to give the opinion, not binding. CJI may say no also. Like for example, you might be knowing about very famous case, Ismail Farooqi case, or what we call Babri Masjid case. There when the government asked the Honorable Supreme Court, or the President asked Honorable Supreme Court that whether there was a Ram Mandir, before the Babri Mosque or vice versa and so on, Supreme Court refused to give the opinion. They said that you had the archaeological department with you, you try to search or find it out by your own, you will not be able to come. So idea is what? Idea is whatever the President is asking, that is not binding on the CJI to reply, and vice versa. Whatever CJI is saying to the President, again it is not binding on the President. So this article 143 is slightly different than what we are discussing here as far as the collegium system is concerned. So this one difference you must be clear with. But as far as this case is concerned, so-called third judge case 1998, that was under or by using article 143, or we can say these type of cases are known as presidential reference cases. So it was a presidential reference case in which the then President K.R. Narayanan was there, and he asked the Honorable Supreme Court or the legal opinion of the Supreme Court as far as the functioning of what? Collegium system is concerned. Now why he asked the functioning of collegium system? Because before this case, what was the collegium system? Collegium system was a authority which is nothing but CJI plus 2. This is the collegium system, and the consultation was binding. But in that what happened, that is in second judge case what happened, in the CJI plus 2, that is 3-member body, there was a primacy principle which had been incorporated. So what was primacy principle? Primacy principle was nothing but the Chief Justice of India in this collegium system had been given the primacy. That is, even if these 2 judges are saying no for any person's appointment, let's say ABC or XYZ, but if CJI is saying yes for the same person, then also the President has to appoint that person. That means ultimate power of appointment of judges in the higher judiciary was in the hand of one single person or single authority. So that single person or single authority had been empowered for what? For the appointment of judges. And in presidential reference case, the same thing had been asked. That how come it's possible for a democratic country like India to give such an extensive power of appointment, taking it from the executive to the judiciary, and that too only in the hands of one person. Like that, this case was referred. So what happened after this presidential reference case, so-called popularly third judge case, the collegium system had been established completely. Beginning is second judge case, but third judge case, after whatever the verdict comes, that is nothing but the collegium system what we have today. So let's try to understand after this reference case, what was the verdict given in the third judge case. So in third judge case, what happened, that the decisions which are given, they are very important in the third judge case. And the first thing, as far as the third judge case is concerned, there they have said this collegium system is nothing but going to have now CJI plus 4 senior most judge. That means they try to make it what? More democratic. When we say more democratic, earlier was what? The CJI, because of the primacy principle, right? He or she was enjoying the sole power, but now that power has been bifurcated as CJI plus 4. That means there would be a 5-member body known as collegium system. And out of this 5, what they said? This is the first thing. They have made or they have added more numbers to the collegium system to make it more democratic. Second thing what they have said, that they must follow the due process as far as the what? Appointment of judges is concerned. That means what? When we say due process, that is CJI must say yes or support to the proposed name. Let's say a name XYG has been proposed, right? And this XYZ must be appointed or not. For that, the consent of the CJI is must. That means again the primacy was there, but it has been diluted a bit. That is the first thing. By this you can see the primacy is there, CJI must say yes. That means what? If these 4 judges are recommending the name of a person XYZ, but if CJI is saying no, then that recommendation will not come to the president. First thing. Second thing in due process, what has been ensured, that the, let's say, third part, that if CJI says no, there is no question only. But if CJI say yes, then it must be what? Based upon the majority. That means out of 5 members, what is the majority? 3:2. So 3:2 probability is two-way. What is two-way? This 3 could be what? CJI plus 2. That makes 3. Otherwise, if you see, then without CJI, 2:3. This 2 is what? Let's say CJI plus 1 and the other remaining senior most judges. So here also they are getting the majority. But this majority will not be accepted. Which majority? In which CJI is not there. That means CJI plus 2 means what? The first thing we need, CJI must have the acceptance. Second thing, along with the CJI, alone CJI's acceptance will not matter. That reference will not be given to, or the recommendation will not be given to the president. If it is CJI plus 2, that is the majority part, then only that will be referred to the President of India for appointing this particular person as a judge. Are you getting the idea? So, in third judge case, first thing what they did, they actually made this body more democratic. Primacy principle still upholds, no doubt about it, but in a weaker format. Why weaker format? Because along with the primacy, they have to focus upon the majority also. And this is called due process. So, they have to apply this due process to appoint the judges. And if this is the scenario and this consultations comes to the president, then it is concurrence. That is, president has to follow this or this is binding. However, if president is not happy, then he can send it back once for reconsideration. That liberty has been given. So, it can be sent once for reconsideration. But if that reconsidered opinion comes back to the president, then it is binding in the second time. So, this liberty had been given just to maintain the democratic nature. What is the democratic nature? Democratic nature is today also, still, if there is a question, who appoint the judges in the higher judiciary or Supreme Court or High Court? So, the answer is what? Very simple. Answer is, it is appointed by the president. So, who is president? President is nothing but part of executive. That means, in front of the world community, in India also, it is the executive who appoints the judges of the Supreme Court or High Court. But what is the change? The change is, initially, these things were used to come from the executive side, right? But now, this is going to come from judiciary side, and that is what is known as collegium system. So, virtual taking over of the power. End of the day, the president is only appointing, that is executive is only appointing. In both the cases, here also it was appointed by the executive, here also appointed by the executive, that is the president. But the things have changed. Rather than executive, that is Council of Ministers sending the recommendation, it will come from the collegium system. And initially it was what? A consultation, but now it is somewhat binding. So these are the two changes. But definitely not everybody is going to be happy with this kind of arrangement, because it is somewhat what? Encroachment of the power. This is what I was trying to elaborate when we had seen the first slide, Nehruvian era, Gandhian era and the coalition era. So as I've told you, here Nehruvian era, legislature was superior, Gandhian era, executive was superior, coalition era, judiciary has to be. But this was supposed to have a break whenever the majority party comes in power, and that happened in what? 2014. In 2014, though it's an NDA government, but BJP was in majority, clear-cut majority, and today also. So there they have tried to change or alter the things. And in the year 2014, that's how the things change. But are you clear about these first three cases? Okay. So in the year 2014, what happened? That government tried to what? Restore back that power of appointment of judges back into the hands of executive, right? And they, for this particular thing, they thought of bringing an amendment, and this is the beginning of NJAC, that was known as 99th Constitutional Amendment Act 2014. So in 2014 they had what? Brought an amendment to regulate the anomaly associated with the appointment of judges. And in this, what they did, in this 99th Constitutional Amendment Act, they had amended again the same article, that is Article 124 of the Constitution, and there they have added the clause or new article, Article 123 Article 124 A, B, C. Basically this A, B, C is what? This Article 124 A, B and C is nothing but what? This is actually mentioning about the structure, composition, function, etc. of a new body, and that new body is known as NJAC. So what does NJAC means? It means National Judicial Appointment Commission. So why they brought this National Judicial Appointment Commission? In the beginning I have told you that the power of appointment and the removal of judges must lies with the executive or the legislature. So here they wanted to bring this back, and this is also this concept of judicial appointment commissions, what we can say, National Judicial Appointment Commission, is what? Mostly practiced in all the developed countries. For example, if we talk about UK, then, or a country like USA, there also if you see the procedure to appoint the judges is what? Is related with some sort of judicial appointment commissions. It is not in the hands of judiciary, though members of judiciary may be there. For example, if we talk about UK, there is a body called Judicial Appointment Commission. Now this body comprises of 15 members. So 15 members are there in this particular commission, but you'll be surprised to know that only 20%, let's say 3 members are from the judicial background or from the judiciary. Rest would be from others. That means judiciary exclusively do not have the right to appoint the judges. Similarly, when we talk about USA, obviously here also judges are appointed by what? King or the queen only. But that king or queen will appoint those judges who are recommended by this particular Judicial Appointment Commission, which is a 15-member body, and then they will appoint. Similarly, in USA also, the judges are going to be appointed by what? The president only. But after making the appointment, they doesn't get the permanent position. Whomsoever the president appoint, that thing goes to Senate, the upper house, just like our Rajya Sabha, and Senate has to approve that by 2/3 majority. But Senate gives the approval only after an appointment commission which is constituted for scrutinizing the appointment of this candidate who is appointed by the president. And that scrutiny is so difficult, no, that they are even called for personality test or interview like what we give in UPSC exams. So a very fair and rational kind of thing is there in these countries. Like that, we also thought that why not to have this kind of body, and it was a good idea to restore back the power of appointment of judges. So that's how this amendment has been brought, 99th Amendment Act. I hope you know how the amendments are done in the Constitution as per Article 368, and there are various types of majorities needed. So here we are not discussing about the amendment procedure, but this was one of the amendment which was enacted to establish a body that is known as NJAC. Then the question comes, what is NJAC and how it is going to help as far as bringing back or restoring? See, the question is same. Judges are to be appointed, right? Whether they are going to be appointed by the executive or whether they are going to be appointed by the judiciary. Initially it was executive till I can say 1993. Post 1993 till today they are by the judiciary. So this power the executive wanted back. This is what the whole game behind the body called NJAC. So government was in majority, they passed this amendment and the body came into existence. Now a little brief about NJAC also, so that you can write 1 or 2 points as far as this thing is concerned. Now NJAC, that is National Judicial Appointment Commission, was finalized, drafted and passed through a constitutional amendment ratified by more than 50% of the states. So it came into existence, no doubt about it. What was the composition and what was the function? What this will do? So basically, as far as the function is concerned, we are very clear. Function is what? Nothing but appointment of judges. So it will take care of the task of appointment of judges. What is the composition? So it will comprise of, or it's a 6-member body. There are going to be 6 people from different walks of life in this NJAC. And those 6 people, obviously it's a commission, so it will be headed by a person, and the head of this appointment commission would be none other than the Chief Justice of India. So CJI plus 5. Who are the other 5? So out of those other 5, the members are what? CJI, again here, 2 senior most judge of the Supreme Court or judges of the Supreme Court. They will be the members. So CJI plus 2, somewhat like a collegium only. And out of the remaining 3, the another 2 members or remaining 3, the another member would be the law minister. So here the law minister at the union level. So law minister at the union level would be also a member of this particular commission. And lastly, 2 eminent persons. So 2 eminent persons would be there. Who are eminent person? What their eminency would be, that is not defined, right? That who all those eminent persons would be. But as far as these are concerned, CJI, it is definitely defined. Senior most judges, obviously. Law minister, confirm. Only the dilemma was this 2 eminent persons. So to resolve this dilemma or to make this body more democratic, what has been done? Here, for this, they said that there would be another committee, right, which will recommend that who this 2 eminent person would be, because more or less we all are eminent only. Nobody believes that they are not eminent. So this committee will be there, and this committee will be having what? 3 members who will decide that who those 2 eminent persons are or were. So that will be having again none other than the Chief Justice of India will be present there. Same. Here, Honorable Prime Minister of India will also be a part of this committee. And lastly, the leader of opposition, LOP. Or if there is no opposition party or leader, then the leader of the largest opposition party, which is the case right now. So what we can say here, largest party who is in opposition, plus Prime Minister and plus Chief Justice of India. These 3 people, please remember, these 3 people are not going to decide about what? The people who are going to be appointed as judges. No, these 3 people of this committee will decide upon who those 2 people who are so-called eminent. Eminent means law professor or anybody who is having a good exposure or knowledge of the law, the polity, the constitution and so on. So those 2 people would be what? Decided by this committee, and after that this 5-member plus CJI, that is 6-member body known as NJAC, will do what? Will recommend for the appointment of judges. To whom? To the president. And then the president is the one who will appoint the judges. So here you can see very clearly there is a proportionate balance. Some members from the judiciary is also there, some member from the government is also there, and some members from the eminent side is also there. More democratic. Is it clear? However, the problem is, before this function or before this commission can start its functioning, it has been again challenged in Supreme Court. And when the matter went into the Supreme Court, then Supreme Court declared that what? This case went into the Supreme Court in 2015, and that is how it is known as 4th judge case. So when we talk about the 4th judge case, again it is by the same association, that is the Supreme Court Advocates on Record Association. They have filed this particular case, and in this particular case the Supreme Court had declared the NJAC, that is National Judicial Appointment Commission, or so-called 99th Amendment Act, as unconstitutional, because ultimately I have told you that the power to review the constitution is what? In the hands of judiciary only, as per Article 222, right? So here, as per Article 132. So here we can say they have declared that this amendment as unconstitutional. So this commission was unable to function even for a day. And when they declared this unconstitutional, just like the 2nd judge case, again they have to give the arguments why they are declaring it unconstitutional. So the most important reason Supreme Court cited behind declaring this unconstitutional was, yes, the first thing, that is, it is going to hamper the independence of the judiciary, right? Because according to Supreme Court, the Constitution itself empowers the various wings of the government to maintain the independence of judiciary, because judiciary is the final interpreter of the Constitution. So here, to maintain the independence of judiciary, if you are going to curb this power by this kind of body, that is not acceptable, or that can be declared as null and void. Second argument, they said that judiciary is what? It's not a generalist body or elected body. It's a professional body. And it needs the judges who must have the sound knowledge and the expertise as far as the functioning of the judiciary is concerned. But the people who are involved in National Judicial Appointment Commission, are they from that background? Whether they can understand the nitties and gritties required for the candidate to have as an eligibility criteria? Because if we talk about CJI and 2 senior most judges, they know, they have studied the law. But what about the law minister? Being a parliamentary form or representative form of government, it's not mandatory for the law minister to be from the law background only. And those two eminent people, they might be or might not be knowing about the judiciary, about the constitution, about the law. So what is the logic behind that? That was the second argument given by the judiciary, that first, it hampers the independence of judiciary. Second, it's a specialized body, so the appointment or the recommendations also must come from the specialized body rather than a generalized body. And lastly, you can add up a couple of more arguments with separation of power or checks and balances as far as justifying the declaration of this amendment as unconstitutional is concerned. So like that, I believe you have understood as far as the 4 judges cases are concerned. And when we talk about the 2nd judge case, again let me take you back. As far as the CJI is concerned, Chief Justice of India is concerned, the practice which was started by Nehru, violated by Mrs. Gandhi, had been firmly established in the form of law, that Chief Justice of India will be what? Appointed on the basis of seniority only. But in 3rd judge case, the merit component also had been added. That is, now the appointment of judges would be based upon merit cum seniority. So what is the idea behind merit cum seniority? Merit cum, if suppose a judge is a junior and he or she does have that ability and possess that qualifications, and the expertise, then he or she may be given the priority as far as the appointment is concerned. So initially it was started with seniority, then it was violated during the Gandhian era, but today what we can say, today we follow the collegium system for the appointment of other judges of Supreme Court and High Court. But as far as the Chief Justice is concerned, then the Chief Justice of India will be or can be appointed based upon seniority as well as the merit component, or we can say merit cum seniority. So I believe that you people have got the idea as far as the NJAC, that is National Judicial Appointment Commission, and the controversy related with the collegium system is concerned. So just to summarize what we have to remember as far as writing the answer is concerned, the first and foremost thing in the intro part, you must remember about the meaning of these two terms, some definitions if associated, historical perspective, how we have done those evolutionary part, and so on. Then in the main body of the answer, what we can mention is nothing but the cases which we have discussed in the form of first judge case, second judge case, third judge case, and fourth judge case. And then when we have to conclude, that is either it's a conclusion or it's a closing statement, right? In that case, conclusion or closing statement, it will depend upon kind of keyword, whether the question is for discuss, examine, critically examine, or comment. It will depend upon that part. But in general, suppose we have to write, then when we talk about this collegium system kind of thing, it may be good for short run, but not definitely for long run, because ultimately you have to quote that wherever we have the democratic form of government, the power of appointment and removal must belong to executive. And suppose it is for critically examine or critically analyze, then you have to say whatever the argument the Supreme Court had given in the second judge case, that political appointment, delays, nepotism, favoritism, and all those things are happening, or corruption, there you can see that or say that as per the statement given by one of the ex-Chief Justice of India, more than 20% judges in this higher court or higher judiciary are corrupt. So don't quote by using your name, by their name you can take. Secondly, if you see the nepotism and favoritism. Nepotism and favoritism, today the story is that more than 50% of the judges are the relatives of one or the other. It's really difficult for ordinary people like you and me to climb up the ladder and to reach to the judges of Supreme Court. So that thing is also getting violated. The same allegations, which the judiciary has put on executive when the appointments were in the hands of executive. The same thing is happening right now also. Third and the last thing what you can say, this practice is flourishing because of the wine and dine culture in our judiciary. That has to be stopped. So for that we need the skew of reforms for making judiciary more transparent, more accountable, and to bridge that trust deficit which is slowly taking place in the minds of people. Because please remember, it is quote from one of the movie which you might have seen, Jolly LLB, that even if today there is a dispute between two or more than two people, they say to each other, we will see you in court. They don't say we'll see you in parliament, we'll see you in executive office. No, they say that we'll see you in court. So the court or the judiciary had that confidence, that trust among the minds of people, relatively much more than the executive and the legislature, and that should not be abrogated. All right, great. So I guess we have done it in a comprehensive manner, and hopefully you are now having a fair and a clear idea about NJAC and the collegium system controversy. Thank you for watching. Looking forward to see you soon. Till then, please do take care of health. Stay home, stay happy, keep smiling, and give regards to your parents and be thankful to them. Thank you.